Good morning, everyone. We'll start from order number 37, summary procedure. So, from this order, important is rule number 1 for the prelim perspective, codes and classes of suits to which the order is applicable. Firstly, which are the codes it is applicable? High courts, city civil courts, and courts of small causes, and as well as to other courts. And with respect to other courts, they have given a proviso that in respect of the courts referred to in Clause B, High Court may by notification in official gazette restrict the operation of this order only to such categories of suits as it deems proper, and also from time to time the circumstances of the case that may require by subsequent notification in the official gazette further restrict, enlarge or vary the categories of suit. So High Court has the power with respect to other courts कौन से सूट्स वो ट्राई करेंगे, उसको वैरी कर सकते, रिस्ट्रिक्ट कर सकते, ऐड ऑन कर सकते, सब कुछ कर सकते. कौन से क्लासेस ऑफ सूट्स है वो नीचे आप एक बार देख लीजिएगा. बिल्स ऑफ एक्सचेंज, हुंडीज, प्रॉमिसरी नोट्स, देन रिकवरी ऑफ डेट वगैरह वगैरह, राइट, which are arising from written contract on or an enactment or on a guarantee, right? So these things, rule number 1, order 37, you must know courts as well as the classes of suits. Institution of summary suit किस तरीके से institute होता है? A plaintiff desires to proceed herein under, he may institute the suit by presenting a plaint. और क्या क्या चीजें होनी चाहिए प्लेंट के अंदर वो उन्होंने बताई हुई है, राइट. And defendant also shall please read sub rule 3. Defendant shall not defend the suit referred to in sub rule 1 unless he enters an appearance, right? So he needs to enter an appearance, and in default of his entering an appearance, the allegations in the plaint shall be deemed to be admitted. Deemed to be admitted hai, and the plaintiff shall be entitled to a decree for any sum not exceeding the sum which is mentioned in the summons, together with the interest at the rate specified, if any, up to the date of the decree, and such sum for costs. So remember this may be determined by the High Court from time to time by rules made in that behalf, and such a decree may be executed herewith, forthwith. Okay. Now procedure कैसा होता है for appearance of the defendant, किस तरीके से he will make an appearance in a suit to which this order is applicable. Plaintiff shall, together with summons under rule number 2, serve on the defendant a copy of the plaint and annexes thereto, and the defendant may at any time, prelim perspective, within 10 days of such service. So remember 10 days. Enter an appearance either in person or by a pleader, and in either case he shall file in court an address for service of notices on him. Right? Remember this sub rule 1, very important. Then sub rule 2 talks about unless otherwise ordered, all summonses, notices, and other judicial processes required to be served on the defendant shall be deemed to have been duly served on him if they are left at the address given by him for such service. On the day of entering the appearance, notice of such appearance shall be given by defendant to whom? To the plaintiff's pleader. Of the plaintiff sues in person, to the plaintiff himself, either by notice delivered at or sent by prepaid letter directed to the address of the plaintiff's pleader or the plaintiff, as the case may be. Then summons for judgment. If the defendant enters an appearance, the plaintiff shall thereafter serve on the defendant a summons for judgment in form number 4 in Appendix B or such other form. In this, you must remember in how many days he must make an appearance or he must answer to the service. It is within 10 days, right? एक interlocutory application है order number 37A. What does interlocutory application means? It means an application to the court in any suit, appeal or proceeding already which is instituted in such court, other than an application for execution of a decree or order or for review of judgment or for leave to appeal. So you must know what is an interlocutory application. Except where otherwise prescribed by rules or otherwise provided by any law for time being in force, an interlocutory application shall state only the order which is prayed for and shall not contain any statement of facts or any argumentative matter. Every application in contravention shall be returned or for amendment or shall it be rejected. Come to order number 38, arrest and attachment before judgment. So it is mean, what does it mean over here? It means during pendency of the suit, right? So over here, you have to read with section number 95. Right? So there is an arrest before judgment, or there is an attachment done before judgment. Why? Logic आप लगाइए, इसमें क्यों ऐसा करते होंगे? They must be doing this because there is a kind of presumption that the plaintiff holds that, there might be some kind of an obstruction on behalf of the defendant, or maybe the defendant is on purpose delaying the plaintiff from getting the reliefs or the remedies which he has claimed, right? So where defendant may be called upon to furnish security for appearance. So, where at any stage of suit other than the suit of nature referred to in section number 16, clause A to D, court is satisfied by an affidavit or otherwise that the defendant, with intent to delay the plaintiff or to avoid the process of the court or to obstruct or to delay the execution of the decree that may be passed against him, has absconded, वो abscond कर रहा है, or he has left the local limits of jurisdiction of the court, or he is about to abscond or leave, or that he has disposed removed from the local limits of jurisdiction of the court certain kind of property, right? That the defendant is about to leave India. So, under a reasonable probability that the plaintiff may be obstructed or be delayed in execution of a decree which has been passed against him. So, in that case, the court may issue a warrant to arrest the defendant and bring him before the court to show cause why he should not furnish his security for his appearance, right? No rule number 1 and no rule number 5, where defendant may be called upon to furnish security for production of property, right? So attachment, that is with respect to rule number 5, and rule number 1 is with respect to arrest. Similar things, where there is a probability that the defendant is going to obstruct the plaintiff in certain ways, maybe by absconding, maybe by leaving, maybe by disposing of his property, or maybe by removing his property, or maybe अपनी property किसी और के नाम पे कर देना. So the plaintiff has certain kind of fear. So on affidavit, the plaintiff files an application with the court where the pendency of the suit is there, and thereby the court will make an order, right? Let's read rule number 5, where defendant may be called upon. इसमें आप लिख दीजिएगा अरेस्ट बिफोर जजमेंट में 94A, जब हमने वो प्रोसीडिंग्स पढ़ा था जो सेक्शन नंबर, और 94B इज रूल नंबर 5. So, where at any stage of a suit, the court is satisfied by affidavit or otherwise that the defendant, with intent to obstruct or to delay the execution of a decree that may be passed against him, is about to dispose of the whole or any part of his property, or is about to remove the whole or any part of his property. The court may direct the defendant within the time fixed either to furnish security in such sum as may be specified in order to produce and place at the disposal of the court, or to appear and show cause why he should not furnish such security. Plaintiff shall, unless court otherwise direct, specify the property required to be attached and the estimated value. The court may also in the order direct the conditional attachment of the whole, or so there is a possibility of conditional attachment also. If any order of attachment is made without complying with the provisions of sub-rule 1 of this rule, such attachment shall be void. Please remember uh, this section. This rules. Rule 1, Rule 5, and 90. With this, we read section number 94A and section number 94B. Also, we will read section number 95, जहाँ पे attachment on insufficient grounds होता है, तो आपको compensation दिया जाता है of up to 50,000 rupees, right? Attachment is a sort of guarantee. The plaintiff does not get title for attachment before the judgment. It is just some kind of guarantee, right? कि वो dispose of नहीं होगी, वो किसी और के नाम पे नहीं होगी. Rule 10. Attachment before judgment does not affect the rights of the stranger, nor does it bar the decree holder for applying from sale. So, attachment before judgment shall not affect the rights which are existing prior to the attachment of persons who are not parties to the suit, यानी कि third party rights. Okay, so it does not bar any person holding a decree against the defendant from applying from sale for sale of the property under attachment in execution of such decree. Important rule number 12: agricultural produce not attachable before judgment, right? Nothing in this order shall be deemed to authorize the plaintiff to apply for attachment of any agricultural produce in the possession of an agriculturist, or to empower the court to order the attachment or production of such produce, right? Small causes court also not to attach immovable property, right? Know this much. Now coming to order number 39, temporary injunctions and interlocutory orders. So injunction, granting of injunction is a discretionary and an equitable remedy. Also, it is a discretionary power of the court. Basically, what does injunction mean? It means to do or to refrain from doing a particular act. Okay, it is a remedy in the form of an order of the court to a particular act, prohibitory as well as mandatory. So आप specific relief act पढ़ते हो, उसमें भी injunctions के बारे में आप पढ़ोगे, right? तो यहाँ पे भी आपको पढ़ना है इंजंक्शंस, क्योंकि मेंस में डायरेक्ट लॉन्ग आंसर आता है इससे रिलेटेड. ओके. So cases in which temporary injunctions may be granted, know this, wherein any suit is proved by affidavit or otherwise. See, यहाँ पे already इन्होंने heading में लिख दिया है may be granted. So obviously it implies that it is a discretionary power of the court. सॉरी इट गॉट म्यूटेड. इसके साथ आप लोग सेक्शन नंबर 94 का सी देखोगे, ग्रांटिंग अ टेम्पररी इंजंक्शन, जो सप्लीमेंटल प्रोसीडिंग्स होती है. जैसे 94A इज अरेस्ट बिफोर जजमेंट, 94B is attachment before judgment. So 94C is also a supplemental proceeding which grants a temporary injunction, right? So similarly we read temporary injunction, यहाँ पे आप लोग 94C भी लिख दीजिएगा, right? Cases जहाँ पे grant किया जाता है that any property is in dispute in a suit or is in a danger of being wasted, damaged or alienated by any party to the suit, or wrongfully being sold in the execution of decree, or that the defendant threatens or intends to remove or dispose of his property with a view to defrauding the creditors, that the defendant threatens to dispose the plaintiff or otherwise causing injury to the plaintiff in relation to the property in dispute in the suit. The court may by order grant a temporary injunction to restrain such an act, or to make such other order for the purpose of staying and preventing wasting, damaging, alienation, sale, removal, disposition of the property, or to or dispossession of the plaintiff, means plaintiff को dispossess कर देना, right? Or otherwise causing injury to the plaintiff in relation to any property in dispute in the suit, as the court thinks fit, until the disposal of the suit or until further orders, right? So please know this. टेम्पररी इंजंक्शन, परपेचुअल इंजंक्शन होता है वो आप लोग स्पेसिफिक रिलीफ एक्ट में पढ़ोगे, सेक्शन नंबर 38 में, राइट? तो वेन एवर यू रीड स्पेसिफिक रिलीफ एक्ट, पे अटेंशन, वहां पे वो इंजंक्शन से रिलेटेड जो पार्ट है दैट ऑल्सो यू मस्ट पे अटेंशन. सिमिलरली यहाँ पे आप एक section number 38, section number 37, specific relief act, these all things you will keep into mind whenever you are studying injunctions, even from CPC, right? So when obviously for prelim perspective they are not going to ask very lengthy questions. Obviously there are 4 options right in front of you, but for mains, if a long answer comes, if you want to make your answer look different, you all can obviously quote both the acts, specific relief act as well as temporary injunctions in CPC, so your answer will automatically look different. But in prelim it's going to be very factual and it's going to be direct, right? So we know what is an injunction. It's a kind of a stay, it's a kind of refrainment, it's a kind of restraint, wherein the act of the defendant is being restrained, it is being stayed, so that the plaintiff, which whatever benefit he's supposed to get, right, he's not been refrained from that. Just keep that in mind. With respect to pre, you must know which order it falls into. Acha, no, rule number 2, injunction to restrain repetition or continuance of breach. Right? In any suit for restraining the defendant from committing a breach of contract or other injury or of any kind, whether compensation is claimed in the suit or not, the plaintiff may at any time after commencement of the suit and either before or after the judgment apply to the court for a temporary injunction to restrain the defendant from committing the breach of contract or injury complained of, or any breach of contract or injury of a like kind arising out of the same contract or relating to the same property or right. The court may by order grant such injunction on such terms as to the duration of the injunction, keeping an account giving security or otherwise as the court thinks fit. Just know this. So what happens? Consequence of disobedience or breach of injunction, क्या consequence होगा? So please read this. इसमें लिखा हुआ है सिविल प्रिजन में डाल सकते हैं not exceeding 3 months unless in the meantime the court directs his release. So अरेस्ट किया जा सकता है, नहीं तो अटैचमेंट ऑफ प्रॉपर्टी हो सकती है 1 ईयर तक, नहीं तो डिटेंशन इन सिविल प्रिजन हो सकती है 3 महीने तक, राइट? See, there are many other things which you should know about injunction. जैसे कि is res judicata applicable on injunction? Yes, but they are not going to ask. अपने यहाँ प्रीलिम में इतना चीजें डिटेल में नहीं जाते हैं. And no injunction against trespassers or a person in unlawful possession, sorry, nor to public projects. ये सब जगह पे आप लोग injunction नहीं मिलता है, right? So these all few things are quite too much in detail, but you do not need to go so much. उसमें जाने की जरूरत नहीं है. Court to dispose of application for injunction within 30 days. So within how many days, in how much time the injunction should be disposed of if there is an application made. So know that 3A talks about that. And before you grant an injunction, अच्छा application तो किया है, but obviously opposite party को notice देना चाहिए कि ऐसा एक application हुआ है injunction का. Appeal is possible with respect to injunction. Revision is also possible, right? That just know. An order for injunction may be discharged, varied, or it can be set aside. Now coming to interlocutory orders. What are interlocutory orders? Power to order interim sale. Power to order interim sale. The court may, on the application of any party to the suit, order the sale by any person named in such order and in such manner and on such terms as it thinks fit of any movable property, right? Which is subject to speedy and natural, being the subject matter of the suit or attached before judgment in such suit, which is subject to speedy and natural decay, or which for any just and sufficient cause it may be desirable to have been sold at once. राइट? सो दैट इज द मीनिंग. किस चीज के लिए आप एप्लीकेशन कर सकते हो. डिटेंशन हो सकता है, प्रिजर्वेशन, इंस्पेक्शन एटसेट्रा ऑफ द सब्जेक्ट मैटर ऑफ द सूट. जहां पे तुम ऐसे करते हो, application करते हो, so the court may on application and on such terms as it thinks fit make an order for detention, preservation, or inspection of the property which is the subject matter of the suit, or for all or any other purpose allow the person to enter upon the land or building which is in possession of the other party, or for taking the samples. So ये 3 चीजों के लिए ऑर्डर किया जा सकता है कोर्ट से. That's it. Remember this much for injunctions and interlocutory orders. कौन से ऑर्डर के अंदर फॉल करता है, know that much. Now direct question. A receiver is appointed under which order? He falls under order number 40, right? And a receiver cannot sue or be sued without the leave of the court. We know that receiver is custodial legis. He is the officer of the court. So whatever any steps he has to take, he cannot do it without the leave of the court. Just know that much. इसमें इन्होंने remuneration, क्या इसकी duties है, क्या इसके powers है. Please read this. Okay, the court may order appointment of a receiver of any property, whether before or after the decree, remove any person from possession or custody of the property, commit the same to the possession, custody or management of the receiver. Now जो इसका D है, रूल नंबर 1 में D, वो उसके पावर्स है. confer upon the receiver all such powers as to bringing and defending suit and for realization, management, protection, preservation, improvement of the property, collection of the rent and profit, वगैरह, execution of the document, or whatever other powers the court thinks fit to devolve on the receiver, right? But that comes under mains. So what you just need to remember is under which order receiver falls. Order number 40. कलेक्टर भी अपॉइंट हो सकता है रिसीवर की तरीके से एग्रीकल्चरल लैंड से, जो wherever the revenue is to be assigned or to be redeemed, right? तो वहाँ उन केस में कलेक्टर जो होता है he can also be appointed as a receiver. अभी हमने ऑर्डर नंबर 41 से ऑनवर्ड्स तो किया ही था सारा हमने, आई थिंक सो वी वेंट ऑन टिल रिव्यू एंड एवरीथिंग, और उसके बाद के जो ऑर्डर्स है ये सब we had done till I think so order number 46 reference, then 47 was review. हमने ये सब तो कर लिया था, and उसके बाद के जो ये orders है, order number 48 is miscellaneous, right? No need to do order number 49, no need to do that. But हाँ, just order number 52 एक बार देख लीजिएगा, lodging of caveat. वो हमने आपको सेक्शन के साथ पढ़ाया था. वी नो दैट व्हाट डज अ कैविएट मीन. इट मीन्स द राइट टू अपीयर. बट इसमें अगर कैविएट से रिलेटेड इंपॉर्टेंट चीज आती है तो आपको उसका सेक्शन ज़्यादा इंपॉर्टेंट मैटर करेगा प्रीलिम पर्सपेक्टिव के लिए. बट इफ इन केस दे विश टू आस्क एन ऑर्डर, so you must know that there is an order number 52 which talks about lodging of caveat, but you better know of section number 148 much more in detail. We know what does a caveat means right to appear, right to be informed in a way. So we had studied section number 148A. So with that only you read order number 52, lodging of caveat. The entire procedure is being given under order number 52. Right? So this is it. आप लोग को मैं important आज ही अपने complete कर देते हैं. I'll just make you all, because then maybe we'll start with contract tomorrow. Okay, just you all can mark down the important things and then we'll end the class. From the sections, section number 2, right? Please know that very, very well. Section 2 in depth. Then section number 10 and 11. Okay, 12, then 10, 11, 12 know it together. Then 13, 14 we know it is foreign judgments, right? फिर 26, then 27, ये तो आपको डिटेल में पता होने चाहिए. ऐसा नहीं, सी आई थिंक आई हैड टोल्ड यू ऑन द स्टार्ट ओनली दैट सेक्शंस तो यू मस्ट नो ऑल इन डेप्थ. बट मुझे जो लगता है आपको जो अच्छे से सेक्शंस आने चाहिए ये वाले हैं. इंस्टीट्यूशन ऑफ सूट, समन्स टू द डिफेंडेंट्स, राइट? So what is the penalty for default? उसमें penalty दी गई है. Section number 30 and 32 we read together, right? Then go to direct judgment and decree falls under which section, right? Section number 20. Then 35, 35A, 35B. मैंने ऐसे बताया था CCD करके आप याद रखना. Cost, compensatory cost and cost for delay. ऐसे याद रखना, right? Execution में section number 46. Section number 47, section number 50, section number 49. Section number 51, section number 55, section number 57, section number 60. Then section 64, section 74. 75 to 78 बहुत लॉजिकल है, कमीशन से रिलेटेड है. ऑर्डर 26 भी आपको इसके साथ पढ़ना है. ये 79 से लेके 87B तक दे आर द सूट्स इन पर्टिकुलर केसेस. जो हमने ये वाले भी सारे ऑर्डर्स पढ़े थे. आई हैड टोल्ड यू ऑल आल्सो दीज ऑर्डर्स. 27 से लेके आपको वो सारे पढ़ने हैं ऑर्डर्स. इन अ वे इफ यू गो टू सी टिल 30, 34, 35, 36 तक. Okay, these are special suits in particular cases, right? Special proceeding 88, 89, 90, 91, 92. अच्छा, 88, 89, 90, 91, 92 know it very well. 94, 95 also. अच्छा, ये appeal 96, 100, 104, 107, 109. Then 113, 114, 115. Okay. Then directly you go to miscellaneous, part 11, entire miscellaneous, all the sections. They are very tiny and very easy to be asked in prelims. Order number 1, please see rule number 1, rule number 8, rule number 13, rule number 9. Okay. Rule number 10, it talks about transposition of parties is possible. That is what is rule number 10. Rule number 9, 10, 11, 13. Then framing of suit, rule number 1, rule number 3, and rule number 7. Then just know what is appointment of the pleaders वगैरह है. Institution of suit, just two rules are. Rule number 9, rule number 9A, rule number 10, rule number 20, rule number 30. Pleadings, order 6, rule number 1, rule number 2, rule number 7, rule number 6. ऐसी कोई चीज एग्जिस्ट करती है, कंडीशन प्रीसिडेंट, आपको पता होना चाहिए. 15, 16, 17, 18. Okay. Then plaint, obviously rule number 1, rule number 10, rule number 11, 12, 13. Order number 8, rule number 1. Okay, just know these things. New facts must be specifically pleaded, denial to be specific, evasive denial, specific denial. अच्छा, set off के बारे में और counter claim, they exist here, and subsequent pleadings. Rule number 9. It has been asked in prelim, तो एक बार देख लेना कहाँ पे exist करता है. Appearances and consequence of non. Rule number 106. There are many things in this, but I'm sure you all are not going to spend time learning all the rules. Death, marriage वाला अब देखो ये 22 है. What is the consequence of death, marriage and insolvency of parties? Know that, right? ये हमने 26, know the heading under what it falls, commission. Then 27 से लेके 34 तक आपको पता होना चाहिए. They are the suits of particular kinds, but 33 important suits by indigent person. कौन indigent person है रूल नंबर 1 में, right? वो आपको पता होना चाहिए. एंड सूट्स रिलेटिंग टू मैटर्स कंसर्निंग फैमिली, उसमें फैमिली का डेफिनेशन भी दिया है. इन कैमरा प्रोसीडिंग्स होता है. कौन सी मैटर्स के ऊपर एप्लीकेबल है रूल नंबर 1, राइट? तो दैट यू विल सी. सो 32A, 33, please know that well. Then 35, interpleader suit, read section number 88, special case suits. 36, summary procedure. 37, arrest and attachment before judgment. And ये सारे तो आपको headings तो पता ही होनी चाहिए, right? Appointment of receiver falls under 41, temporary injunction falls under 40 is receiver, 39 is temporary injunction वगैरह आपको ये पता होना चाहिए. We'll stop the class here. I'll see you all tomorrow.